unmute, and then I think you need to select English. Mr. Williams, let me know when.
I'm back, Judge, and I managed to figure out how to do this on my phone.
Great. So I was at sentencing. Were you still there? I wasn't sure when you froze.
I was, Judge.
Okay, so then I will resume there. Ms. Lechuga, your attorney is now back and can hear us. So Ms. Lechuga, on your plea of guilty and the evidence adduced, I will accept your plea. At this time, find the evidence substantiates your guilt, finding you guilty in counts 1 and 2 of smuggling of persons for pecuniary benefit. I will follow the plea agreement, sentence you to 5 years confinement, suspended for 5 years of community supervision. I think that's where I was asking you, Mr. Williams, if you were appointed or retained.
Appointed, Judge.
Okay, so based on your client's indigency, I will probate the entirety of the fine, 300 hours of community service, urine and breath analysis, curfew. You're to have no contact with the co-defendant, Valentin Delgado. I will also, actually, I believe I've already signed the dismissal in cause number 2022-0D05198. Is there anything further, Mr. Munson?
Nothing further from the state.
Mr. Williams?
Nothing further, Judge.
Good luck to you, Ms. Lechuga. We are adjourned on that case. Who is next?
Thank you, Judge. Can I be excused?
You can. Do we need the interpreter for anybody else?
Not to my knowledge, Judge.
Anyone need the interpreter? We turn off the function. Okay, last call for the interpreter. Thank you, Ms. Hernandez.
Thank you, Judge.
Judge, I kind of have an interpreter issue.
You what?
I sort of have an interpreter issue. My interpreter issue is that my client didn't send any plea papers when we were set for a plea, Judge.
Yeah.
And we requested it to be rescheduled for Thursday.
Is that Mr. Pace?
Yes,
Okay. So you want to bring him over at 11? Do you want to do it in person? See?
please,
Okay.
yes.
So let's get that taken care of and we'll see you on Mr. Pace at 11 Thursday.
Thank you, Judge. May I be excused?
You may take care.
Thank you. Bye-bye.
Okay.
So I'm excused, Your Honor.
Sounds like it. I think
Okay.
Mr. Ortiz cheated and got in on the interpreter question there.
I think so.
Smart guy. All right, who's next?
Thank you,
Thank
Judge.
you, Ms. Hernandez. Have a good
Bye.
afternoon.
You
Bye-bye.
too, Judge. Thank you.
Bottom up, page 23, Judge.
Mhm.
Annex, may we have Ulloa, Alexander Ulloa?
Sure, give me 1 second. Go up.
Loa. Zero, 7, 8. All right, go ahead.
In cause number 2023-0D00178, State of Texas versus Alexander Ruben Ulloa. Announcement of council, please.
Eliana Elizalde for the state. State is ready.
Jaime Olivas for Alexander Ulloa. We are ready, Judge.
And Mr. Loa is appearing from the jail annex. We are scheduled for a bond hearing today. I will say this, I know I have some emails kind of pending here in the last few hours, Mr. Olivas. I can tell you I have not looked at those yet because I was out of the office. So you might have to get me up to speed a little bit, but we're set for a bond hearing. You may proceed.
Thank you, Judge. Your Honor, Mr. Ulloa is currently incarcerated since December 11th of last year. Basically, what happened in November of 2021, he picked up a charge for burglary of a habitation. And thereafter, a year and a month later, he picked up an assault family violence with his Ruby Ulloa, his common law / girlfriend. Your Honor, Mr. Ulloa is a 35-year-old individual. He was born and raised here in El Paso, Texas. He attended Montwood High School and graduated in 2004. He's previously held the job as a machine operator for 17 years. He has an ex-wife of Martha Arredondo whom he has a good relationship with, and 2 children from that marriage, 2 girls, an 8-year-old and a 10-year-old, for which he pays child support. He also has a sister here in El Paso that's a lifelong resident. Your Honor, his address is at 429 Tanya. This is the family home that they've owned for his entire life. Last year, Judge, Mr. Ulloa suffered a hemorrhagic stroke, a severe stroke at that, and he was currently, or in January of this year, he has been officially or disabled by the Social Security Agency. He is currently taking Keppra. However, he is not getting the sufficient amount of, he's not getting the painkiller, nor is he getting the anti-anxiety medicine. And my understanding is that he continues to suffer seizures while incarcerated. Judge, the reason there's a couple of issues that are concerning to me. The email that I sent you, Judge, is at any rate, let me finish. Let me go back. As a result of the arrest of December of last year, December 11th, that they placed the bond of $50,000 on that case. They revoked the PR bond on the burglary of habitation and placed the bond of $20,000 cash or corporate surety. Your Honor, he is not employable because of his disability. He is in need of medical attention and continued medication, and he's asking the judge to reduce the bond. In regards to the burglary of habitation that happened in 2021, Your Honor, he was out for over a year and a month without any issues. Basically, Your Honor, he had a rental home that he got an order evicting the tenants. I believe it was a couple of military individuals. When he went to evict them, and we have the paperwork, Your Honor, he was told by the cops not to, this was in May of 2021. He was told by the cops, you can't do it yourself, get out. So he did, and he left. In November, apparently the complaining witness of the burglary, it's his home and he has an eviction order. Apparently the complaining witness said that he stole a cell phone, which is impossible because they were there at the time. And there's no way that he could have stolen the cell phone. At any rate, those charges came back in November of the 22nd. In regards to, as a result of the arrest of December 22nd, Judge, is the reason they revoked that bond. Now, in reference to the December 11 charge, the assault family violence, Your Honor, the indictment, and that's the email that I sent the court, the indictment claims on 2007 0C0. This is a family violence enhanced because supposedly of a prior conviction. The indictment listed 2007 0C0 7858 lists a totally different defendant, and her name is Rosana Rivas, Judge. I believe that the DA's, for some reason, it references this case, but this cause number is not Mr. Ulloa. As such, this court would not have jurisdiction because it would be a misdemeanor. There is a listing as a related case. I cannot find it. I need to investigate it. But at any rate, Judge, Mr. Ulloa is basically earning $730 a month in Social Security disability that he's making. He cannot afford these bonds. Respectfully, Your Honor, we are convinced that he is not a continuing danger to the community. The complaining witness, Ms. Ulloa, has indicated that she is not particularly interested in pursuing the charges. Nonetheless, they're still pending. And these amounts of $50,000 and $20,000, Judge, basically in violation of 1715. This was placed, these amounts were posted at the magistrates. I think they have, because he cannot afford it and he cannot employ, they basically are working to oppress him. In terms of the nature of the incident, it's basically a misdemeanor, Judge. With that enhancement may or may not be valid, but at this point, it's a misdemeanor charge. There is no ability for him to make these bonds, and there is no danger to the community, Judge. Mr. Ulloa is running some extremely dangerous medical conditions by not receiving the amount of or the proper medication that the doctor has prescribed. And respectfully, Judge, we're asking this court to convert the $50,000 cash or corporate surety on the assault family violence into a $5,000 bond, and then the $20,000 cash or corporate surety bond for the burglary imitation to be PR, Judge. While he was on PR, he complied. He complied with all the requests, always appeared, never had an issue of not checking in, not reporting, or any drug use or anything of that nature. It's simply an argument that got out of hand that we understand we're going to be able to resolve. And indeed, there is an issue as to whether it is a felony at this point or not. Thank
So
you,
let me
Judge.
just, thank you, Mr. Olivas. Let me just quickly, as you were talking, I looked up the indictment. I see a cause number there as the prior being 2007 0C07858. When I pull that up on Odyssey, it's him. So am I missing something?
Well, there's the one I look has a Rosana Rivas, Judge, and I don't know if it's a related case. I need to get to the bottom of it because his name comes up on top, but the defendant, if you see where the defendant sentenced to 5 days incarceration, it's Rosana Rivas. That's what I don't understand.
So looking up in Odyssey, 2007 0C07858. I'm not sure where the judgment shows up here, but I see maybe this plea before the court. Alexander Ruben Ulloa. And you were representing him there. Yeah, so it looks like he pled to that, time served on September 10th, 2007.
5 days.
So there's
My
that.
My showing Rosana Rios, and that was the one that, like I said, I need to get to the bottom of that. Perhaps it might be a different number, but I think I can resolve that.
Let me confirm, Ms. Elizalde, the prior listed on the indictment, is it that cause number? Let me go back to the indictment.
It is, Your Honor.
Okay. All right. And then with respect to his bond on the assault family violence, the 178, it is a split cash surety PR, right? 25-25. Okay.
Correct.
All right, Ms. Elizalde, and I did see, I guess we had a hearing with Judge Reyes and there was the bond reduction was denied.
Yes, Judge.
Okay.
Judge, I was not part of that hearing. I did not get notice. I just saw the order, but we were not able to present any evidence, proffer any evidence, Judge. My apologies.
Was there a hearing?
I believe there was a different attorney on the case, Your Honor.
Oh, I see. I'm sorry. Okay. All right. All right. Anything else, Mr. Olivas, before I go to Ms. Elizalde?
Not at this time, Judge. Thank you for your courtesy.
Ms. Elizalde, go ahead.
Judge, first, you mentioned a couple emails. Was I included in those emails regarding this case?
Let me see.
No, you weren't, Ms. Elizalde. I didn't send those until later, and I wasn't certain who was the DA handling this case.
And so I'm clear, and I know there's probably not a real distinction here. I guess he sent them over to the court, to Ms. Hernandez or Becky's email, and she forwarded them to me. I'll tell you this, you were not copied on these, and being that I was out of the office from the second we finished our morning docket until 2 minutes before we started our afternoon docket, I had not looked at them, so yeah.
And the basis of those emails is just what Mr. Olivas has already mentioned today. Is that?
Correct.
This is what I see. On one, there's an attached, there are two attachments regarding a motion to substitute counsel. And the next one has an attachment with that cause number. And I haven't opened them. I mean, they're there. I haven't had time to do anything with them.
Mr. Olivas,
So-
if you could be kind enough to send those to me after the hearing, it'd be much appreciated, okay?
Very well, thank you. My apologies.
Oh, no, I understand. Okay, Judge, so we have been here before. This is a new case, so I'm just gonna briefly go off of the facts because this is an extremely concerning case. Officers were dispatched in reference to a domestic disturbance. The
Mhm.
officers observed the CW running from the front yard, screaming for help. CW stated she was scared for her life because the defendant was mentally unstable and had assaulted her. CW came home and the defendant started yelling at her. He then grabbed her and threw her outside of her vehicle on the sidewalk. The defendant told her to leave and that he didn't want her there. She ran to her room. He grabbed her and pushed her down to the ground. He then got on top of her, held her down for approximately 20 seconds or more, preventing her from moving or escaping. She had visible injuries, a fresh 2-inch laceration on her right hand with a small amount of blood on it. Thereafter, defendant was aggressive with officers. He removed his t-shirt and assumed a fighting stance. He asked the officers if they wanted to fight. He then ran back inside the residence and came back to yell that he had a gun. Officers did.
Slow down a little bit, please, Miss Leon.
Sure. Do you need me to repeat anything I just said?
No, it's okay.
Officers did not observe the gun. Defendant told officers over the phone that he would not come out until he got what he requested. When asked what that was, he said a 6-pack of beers. I'm gonna move on to the criminal history here. Terroristic threat in 2000, that was juvenile, it was dismissed. A burglary of a building in 2000. Harassment in 2006, which probation was revoked in 2007. Burglary of building, 2007, 60 days. The assault, family violence in 2007, and a DWI in 2016. Judge, we think he is a danger to this victim. We also, he's been revoked on probation before, indicating that he does not listen to court orders. I can tell you, I was present at the last hearing. We did talk about the burglary of habitation. Judge Reyes did consider that when denying the bond. The state's position is we object to modification. We believe he's a danger to the community, specifically this victim. His record is extremely concerning. And finally, Judge, we do not believe there's been a change in circumstances that would warrant a modification of bond, especially given the officer's observations and his conduct with officers.
Okay, Mr. Olivas, did you have anything else?
Yes, Your Honors, just briefly, the revocation, my understanding for the probation occurred back in 2006. This is the case that was generated by Socorro PD, Your Honor. And the witness, or the alleged complaining witness, my understanding that the injury was to her right hand is because she swung and hit a wall. There was an argument, but it didn't escalate beyond that. She did not need treatment nor hospitalization. And at this point, there has been no contact or unwarranted contact between the complaining witness and Mr. Ulloa, Judge. Thank you.
Mr. Olivas, what resources does he have towards a bond?
Your Honor, simply the Social Security that he is making, that he's been paying, that he's started to receive since January. That is all that he's got, Judge. He cannot work because of his disability as a result. His whole left side is in the state of paralysis. Not entirely, but he is paralyzed from working, Judge.
Ms. Elizalde, in terms of the AFV or assault or violent priors, are we just talking about one prior, like the 2007 AFV? Or I'm sorry if I missed it in your priors list.
Judge, you are correct. It's one AFE in 2007, but he does have other concerning records, such as a harassment that he was revoked on.
All right. I am going to make a slight change in the bond. And so we're going to go down to 30,000, 15,000 cash surety, 15,000 PR. His conditions are going to be to report monthly to the PR bond office, to have no contact through any means with the complaining witness. He will be subject to testing. He is to use no illegal drug or alcohol, commit no new offenses. He must not change his place of residence or leave El Paso County without court permission, and provide current contact information to the PR bond office. May not possess any weapons, firearms, or ammunition during the pendency of the case. And if there are any mental health, there's a notation on the previous PR bond order that he continued to participate with Takumi. If that is still available, quite honestly, it'll be a more general compliance with any mental health treatment that he's, if he was with Takumi, so be it, but he must comply with any other mental health treatment, to include taking medication or anything of that nature. That's as far as I can go on that, Mr. Olivas, considering his prior non-compliance and the nature and circumstances, safety of the victim and the community. So we'll get a new bond order there. If you need to
Thank
come
you.
back for any reason, let me know.
Judge, I do have a question in regards to the $20,000 bond for the burglary of habitation. Could the court
Oh.
reinstate? He's got two.
Mhm.
Could the
Let
court
me go
reinstate?
back. Let me
PR?
go back. I hear what you're saying. Let me go back. Ms. Elizalde, where is that burglary of habitation?
You know, Judge, I recall the burglary of habitation, and I was able to see it the last time, and now it's not popping off. My last conversation with Intic was that it was gonna get indicted.
Your
The
Honor,
question was how it was gonna get indicted.
Monday, Marissa.
Your Honor, I have information on that. The burglary of habitation, the warrant number is now registering as assigned to CC2 with Judge Gonzalez. It's 2023-0C01187. It's now listed as a theft of property between $750 and $2,500.
And the bond is what?
I think it's still the same 20,000. It's set for a bond hearing on the 30th.
Okay. There you go, Mr. Olivas.
Very
Are you on that case?
Yes, Judge, just that it was on my paperwork or my computer's coming out as a felony
Sure.
with it.
Okay. Well, now we know. All right. That'll be the order. Thank you for your time.
Thank you, Judge. May I be
Take care.
excused?
You may.
Bye-bye.
Mr. Loa, who's next?
Staying on page 23, Judge, bottom of
Mhm.
page 23.
Mm-hmm.
In cause number 2021-0D01401, State of Texas versus Xavier, Jonah, Rochelle, announcement of council, please.
And Elizalde for the state is ready.
Jaime Gándara, pues, Javier Rochelle, will there, Your Honor.
And we're set for a probation status hearing today. Is he the one at downtown? Okay, Mr. Rochelle is appearing from the downtown jail facility. Is that your client, Mr. Gandara?
Yes, Your Honor.
Okay. How are you doing, Mr. Gandara?
I'm getting along okay under the circumstances.
Well, I appreciate you being here today. Thank you very much. Okay, probation status hearing. Let's see. So I guess we had a bench warrant back in October. Carla, I'm trying to get to your summaries. Let's see, there it is. He's been in custody a little
He's
around.
been in federal custody since October, Your Honor.
Okay.
And he was in federal custody until brought back here just a few days ago. And he's finished doing his time up there.
Okay. Let's see. So when was he in custody?
He was in custody periodically during 2022. He was arrested and released a time or two, but he was arrested again in October and been continuously in custody since then. I think Your Honor, you put him on probation in May.
Mm-hmm. Let me see. Let me go back up. And he was, May 10th, 2022. He's due to go till 2025, and he picks up, well, aside from not reporting, they had him down as an absconder, but he was failing to report in June right off the bat. What is this?
Your Honor, if I may, I believe he was also rearrested. I'm sorry, I'm not sure if you mentioned that.
See that?
Rearrested. I am trying to verify with the probation officer just to make sure. I know that it's mentioned that he failed to report at the beginning, but if I recall, he was ordered to attend some kind of federal treatment when he pled last year. So I'm trying to get those details to see if he did attend and was released from any of that.
Well, he did, his probation on the federal side was revoked, and he was sentenced to 6 months. Judge Briones sentenced him to 6 months to do, and he did the 6 months, and he returned here on Your Honor's capias and on the
And so, Mr. Gandara, why does he want to be on probation? I mean, doesn't sound like he does very well on probation.
well, he wants an opportunity to get this one done on probation, Your Honor. That's his situation. I think the cases are, is it violation of protective order?
Yes, sir.
And so I can't get access. I have to pound on the DA portal to get access to the file, so I don't know as much about the underlying cases I would like to, because I don't think there's a motion to revoke filed yet.
Yeah, I don't see the motion either. Do we not have a motion yet?
Judge, a motion has not been filed. I do intend to file it or request it. I'm not sure that I was sent the VN, but I could be wrong, Judge.
Yeah, I don't know. Let's see. I'm not sure if I want to keep him on probation. It looks like he was having issues. I mean, what turned him around? The fact that he's been in custody? I mean,
I would suggest that that's had a strong influence on his views about how he needs to behave, Your Honor. I've got some letters that I hadn't had a chance yet to forward to the court about employers that have worked with him and are still willing to work with him. And indications from his family. He's got support from both his grandmother and his mother. His mother lives out of state in Arizona, but she's been very supportive of him in this circumstance. And he has, there is some saving grace there.
oh, in terms of his priors, he's got some drug priors. He's got an ag assault, deadly weapon, and then we get to this one. And it looks like he has some credit there. He's got 77 days back in 2020. Is that right? And then
I believe so, Your Honor.
And 17. Is that the same case? Probably. You know, he's got some credit. Well, if there's something that's going to help change my mind about why we need to save this deferred. I'm not there though, Mr. Gondeta. I'll be pretty straightforward with you. I'm not there right now. So I'm happy to reset this for 30 days. And we can look at it then if you have some additional information. Ms. Elizalde, I'm sorry, I didn't ask if you had a recommendation.
Judge, after reading the report and the underlying offense, which by itself says he doesn't listen to court orders,
That's true.
I was already at TDC, 3 TDC. He got revoked on federal probation. I mean, that's where I was coming into the hearing, Judge, and I don't think I've changed my mind on that either.
Yeah, that's all very good points. I will say that, of course, probation is recommending an extension and assessment through TAP. That's definitely. He only has 55 days, Marissa? I thought I saw a stint in 20. Where was it?
He had a 2020 case, but that one was dismissed. He pled on a 2021 case, and the time credit that I'm showing It is from August, the original arrest date, August 25th to 2021 through September 10th, 2021 for 17 days. Again, in 2022, April 19th through May 11th for 23 days. And then the current arrest, March 14th through today for 15 days.
The booking that begins October 7, 2020, that's the other case. It predates this one?
Yes, Your Honor.
Okay, so those 77 aren't, okay. All right. Yeah, we can reset this for 30 days.
All right, Your Honor,
Okay.
I'll look at it and I just end with that if you keep him on deferred, give him a shot to come back out into the world, I think he'll get it done, and if not, you've still got a shot at him for the full range on revocation.
Yeah,
Your Honor, if
unfortunately. Mr. Rochelle, your attorney is here to speak for you. So Mr. Gandara, I don't know if you want to advise your client. I can't imagine you're going to tell me much right now. Let Mr. Gandara maybe lay a little bit of the groundwork for anything you want to express to the court, but your entire history tells me you're not a candidate for probation. So I'll let you ruminate on that with your attorney, discuss it with your attorney, and we'll come back in 30 days, Mr. Gandara.
Thank you, Your Honor.
Thank you.
I just want to ask for an opportunity to give my probation reinstated. I've came a long ways with drug addictions. I haven't had a dirty UA in almost 2 years. I've had a very—
Mr. Rochelle, talk to your attorney, okay? We'll see you in 30 days.
I'll be over to see you at downtown, Mr. Rochelle.
Thank you, Mr. Gandara. If
Yeah,
you need
big
the court's
excuse, yeah.
assistance in it, absolutely. If you need the court's assistance in any way, I don't know how you're getting around, but we're here to help if we can, okay?
Thank you, Your Honor.
Okay,
May I leave?
who's next? Yeah, we're adjourned. Thank you.
Middle of page 22, Judge. Annex, may we have Randy Martel and Christopher Martel?
Yes, sir. Give us 1 second, sir.
No, Judge.
Oh, Miss King, hello.
How are you?
I'm well. How are you doing?
I'm good, thank you.
No.
What?
In cause number 2021-0D0-0640 and 2021-0D0-0641, State of Texas versus Randy Alexander Martel and Christopher Rick Martel. Announcement of counsel, please.
Revoking for the state of Texas. State is ready. Good afternoon, Your Honor.
Felix Valenzuela, Mr. Joe Spencer for Randy, both Martels.
Good afternoon, Your Honor.
Good afternoon, Mr. Spencer. Okay, so we're set today for, good afternoon, everyone. We're set today for a final judges conference in each of these cases. Wow, our special setting is here. Where are we? I feel this case has been kind of ominously quiet. And if memory serves, I think, Mr. Spencer, you're supposed to be in a trial here pretty soon, no? Or
We started trial on, Mr. Valenzuela and I both started trial on Thursday, Your Honor.
okay, Thursday.
We just received an email from Ms. King telling us where they are with respect to the analysis that was being done by forensics. And as I understand it, she believes, has been represented to her, that they will have the analysis completed by the end of April. That's correct, Ms. King?
Yes, that is correct. For the analysis and the second part, which is the review part. And if there's any changes, they will keep me posted. And I will keep opposing counsel posted as well.
So once we get that, Judge, we would request at least 30 days or so to review that and see if we need to have our own experts analyze any of that. So I'm hoping maybe we can have a conference, a status conference in May.
I just looked here. I'm looking at May 2nd. it may be a little bit premature for defense counsel to get the court up to speed, but I certainly want to keep track of where the state is at that point. So we'll do May 2nd at 3 p.m. I am no longer going to set this unless you all are requesting for a specific trial date, since we are now going past our backup date. So this will be a final judges conference for May 2nd, 3 p.m. And then we'll go from there. So unless I hear something from you all that you actually want a trial setting, I really need to caution you all that the court's docket is just getting really full with special settings. So I really don't even feel comfortable telling you anything sooner than the end of this year. And that even that, I'm trying to think of a week that we could fit you in. So please keep that in mind as we keep going past these trial dates, okay? But sounds good. As long as you all are staying in communication, then we will see you on May 2nd.
Good. Thank you, Your Honor. I
Thank you.
appreciate the consideration, and may we be
Absolutely.
excused?
You may. Thank you for your
Thank you.
time, all of you. Thank you, Ms. King.
Thank you, Judge.
All right, who's next?
Top of page 21, Judge.
Becky, on those two, then we can cancel both the final hearing plea deadline and backup trial with that new reset, okay?
Yes, ma'am.
Thank you. All right, go ahead.
Annex, may we have Benjamin Contreras?
Let me write out your.
Mr. Avila, are you still urging the motion to withdraw?
We are, Judge.
Okay, Becky, can you get me on Benjamin Contreras, 1785, the next 5 attorneys, please?
Yes, ma'am.
Thank you. Mr. Contreras, okay.
In cause number 2021-0D01785, State of Texas versus Benjamin Contreras. Announcement of counsel, please.
Eliana Elizalde for the state. State is ready.
And Daniel Avalar for Benjamin Contreras.
Okay, I have that's strange. I have a schedule for a pre-revocation hearing today, but we have a defense motion to withdraw. We may have briefly addressed this last time when we were here, but Mr. Avalar, you want to go ahead and let me know what's going on?
Judge, with respect to our motion?
Yes.
Yeah, Judge, our grounds are that our communication has broken down to the point where effective representation is no longer attainable, Judge.
Mr. Contreras, let me ask Ms. Elizalde, where were we last time? Was it 2, 3 TTC? What was it?
We came down to 2, Your Honor. We
Okay.
sent steps and waivers, and then we had this happen.
Okay, Mr. Contreras, are you going to hire your own attorney?
I'm willing to sign 2. I've been willing to sign 2 for 2 months now.
May I, Judge?
Mm-hmm.
And I don't want to give any attorney-client discussions away, Judge, but that was not the discussion the last time we spoke, Judge.
Okay. So I'm not sure what's going on here, but based on Mr. Avalar's representation and the firm's representation of having some issues communicating with you, I'm not exactly going to ask all of those details other than to say that, well, I'm trying to remember what happened at the last hearing. There was an issue at the last hearing. In any event, I'm going to go ahead and grant the motion to withdraw. I'm going to appoint Mr. Dennis Moore to represent you, and you're going to come back in 1 week, Mr. Contreras. Well, actually, no, it's not going to be 1 week. What's today?
My next hearing's on April 10th.
Ms. Elizalde, is someone covering for you that week? I wasn't sure.
Yes, someone will be covering for me that week.
Okay. So I'm gonna go ahead and set it for April 4th at 3 p.m. We're gonna reset today's pre-revo for that time.
April 4th will be a pre-revel, not the.
We're gonna reset for today and bring in Mr. Moore to handle the pre-revo. We'll get him the order appointing right away so that he can meet with Mr. Contreras before that hearing and see where we end up. Okay, Mr. Contreras, we're gonna get you a new attorney.
Thank you.
Thank you, Mr. Avalar.
Thank you, Judge. Appreciate it.
Who's next?
Yeah,
Towards the bottom of
You may.
page 22, Judge. Annex, we have Mejia, Mario Mejia.
Let me read out. Yeah. 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 Yeah.
Go ahead.
Clause number 2013-0D03853, State of Texas versus Mario Miguel Mejia. Announcement of council, please.
Eliana Elizalde for the state is ready.
Manuel Parra for Mr. Mejia, Your Honor, also ready.
And Mr. Mejia is appearing from the jail annex. We are scheduled today for a pre-revocation hearing. Let me look at this. He's been in custody now for close to 60 days. At 221. Mr. Parra, had you had a chance to get up to speed? I know it's been a minute and we've had a setting or two. The probation recommendation is an extension of 24 months so that he can complete his treatment.
And Your Honor, that's absolutely something that we would look to accept, Judge, to show how serious he is about complying. I know he's been in custody for 60 days. It's my understanding he hasn't been in custody that long before, Judge. And as much as he might be lacking in some conditions, Judge, it seems to me that he had been making an effort such that I think that extension would do him well.
Miss Lerma, you're here on Mr. Mejia's case?
I am, Your Honor.
I know in other cases, I got to think this is one of those review cases. There was a little more detail, I think, as to how, is this going to be some type of, what do I call it? I'm not going to call it expedited treatment, but I think you had another probationer who, was it your client as well, Mr. Parra, that had the complete 3 or 4, no, it was a different attorney? 3 or 4 lessons. It's kind of like the treatment is, they're kind of put on a little bit more intensive schedule, Mr. Parra, and that to me is helpful in showing the court that they're taking it seriously this time with the type of treatment it is. It's so critical to this type of probation for them to be compliant there that when they're not compliant, and I'm pretty much saying this so your client will understand, will go a long way in showing the court that we're going to be on track. When does he term? Let me see, 14. So he's in June of next year. Do we have an idea how much he needs to do in terms of the treatment, Ms. Lerma?
Your Honor, he was actually pretty close. He just needs to deal with the violations of just all the absences, pay his fee, which I believe is like $105 or $110 is what his balance was, and then he can get started.
Do we have a motion? No, I'm sorry. Do we have a motion pending on him?
No, as far as I don't know.
Oh, did I not file it?
Let me see. It's such an old case. The motion to revoke, motion to adjudicate is filed 131, I believe. So we do have the motion. Okay, so Mr. Parra, this is my proposal. We're going to leave the motion open What I
Yes,
would
Your Honor.
like to know, Ms. Lerma, is if we have a turnaround time by which he would that he would complete the treatment that I believe they go to the next stage. If you can get me that information, Mr. Parra, I want to leave the motion pending. He's due to term next year, 2024. If he's on track, great.
Understood, Your Honor.
If things start to fall apart and it's not handled in a way that I guess a responsible way, in other words, communicating with his probation officer, coming to the court, that kind of thing, we have the motion, ¿verdad? We have the motion there pending. He does what he needs to do. We get to June 2024 and he completes successfully.
Understood, Your Honor.
Okay, so what I will tell you, Mr. Parra, is that once I get that information from Ms. Lerma about what we're looking at on completion of the treatment, I will set a status hearing probably 30 days after that. And just so I can, get an update at that point. He will remain on probation for today. He'll be released to the streets to resume his probation. And that means, Mr. Mejia, is when you resume your probation, that means you need to get up to speed on everything. Any of those conditions, I better see full compliance on those. And if you're not, you better have a good reason to Ms. Lerma so she can come tell me why I'm not going to move on that motion. Understood? Okay. Mr. Parra, to me, that's kind of with, how long he's been on thus far and all of the issues, the best way to handle it and hopefully keep the pressure there a little bit to give him an incentive to be compliant.
Yes, Judge.
Okay.
Understood.
All right. So, Ms. Lerma, did you have some more info or something?
I just have one question, Your Honor. Will he be returning to his family because
modification?
No, ma'am. We know those restrictions, and my understanding, Your Honor, that he's not allowed to go back there at least until he's completed the treatment and we get permission from the court. Judge.
Right. And that's exactly where I am. And so we'll have that hearing. Just, Ms. Lerma, please, if you have an idea, I just want to make sure it's something probably I'm thinking around 6 or 7 months out. But at that point, we need to address it again, Mr. Parra. We'll look at it then. Okay?
Understood, Judge.
Yes, ma'am.
All right. Thank you so much. Okay. You may. Thank you, Mr. Parra. Who's next?
Middle of page 21, Judge.
Mm-hmm.
In cause number 2023-0D00582, State of Texas versus Luciano Sierra Flores. Announcement of counsel, please.
Juliana Elizalde for the state. State is ready.
Do we have an attorney?
Yes, Mr. Uraga.
Hi, Judge. Good afternoon.
Oh, sorry. I didn't see you there. Okay, go ahead. Mr. Uraga, are you representing Mr. Flores?
Yes, I am, Your Honor. Judge, I'm not 100% sure why the case was set for a motion or a bond hearing. I've been asking about this hearing because my client is out on bond. So I was told that it was kind of like a bond review hearing.
That's exactly what it is. And so when I had said it, he didn't have an attorney. And so we were inquiring if he was going to have an attorney. Really, the only thing I am going to do is, and you know what, I don't have my most current notes on him, is add a PR bond condition, PR bond component due to the nature of the offense, that being assault, family violence. I want a no offensive contact with the complainant on this one.
Okay.
Okay. So because I don't have my current notes, I'm trying to think, then let me look up what his bond is. I thought it was 10,000 cash surety, but let me go and check. I'm sorry, 5,000 cash surety. Marissa, do you see the most recent bond order?
Just a moment, Your Honor. I'll see if I can find it.
So I think he's at 5,000 cash surety. I'm going to split that to 4,000 cash surety, 1,000 PR to report once a month by phone to the PR bond office. Subject to testing, use no illegal drug or alcohol. Not change his place. Well, just maintain current contact information with the PR bond office. Mr. Uraga, I believe he's appeared at the prior 2 hearings, or at least 1 hearing when he didn't have an attorney. So we may have covered with him the reporting for court requirements, but I know you will go over those so we don't have any issues there. The main thing I want in terms of the PR bond conditions is that there be no offensive contact with the complainant in this case.
Will do, Your Honor. And I'll go ahead and explain that to my client. Is he gonna have to report or be interviewed by the PR department?
He may. I don't know that we ever, Marissa, maybe you can help me on that one. I don't know that we've ever done that while we're here. Maybe the order goes through and then PR gets in touch with him. Marissa, do you know how that works? Or
yes, we'll need to contact CJC since he's not in custody. Normally when we do the bond hearings, they're in custody, so they have a CJC person there interviewing them via video at the at the annex.
So we need someone from PR right now?
Yes, ma'am. I'll get the order to you right away.
Okay. So if Mr. Flores, and you're welcome to stay on as well, Mr. Uraga, we'll go ahead and get PR bond here so they can take down his information.
Okay, we'll do, Your Honor.
Thank you. Becky or Marufo, if we can get PR bond on here, please, so we can get him squared away. We can put him in a breakout room. That's no biggie.
Yes, ma'am.
Thank you. All right, Mr. Flores, if you'll just hang on, PR bond's going to be here in a second to take some information from you, okay? I'm assuming he said yes.
Yeah, you're muted, Mr. Flores. You need to unmute yourself.
Right there?
Yes, sir.
Okay, I was gonna ask you a question, since I'm not gonna be allowed to be in contact with my wife, right?
No offensive contact.
Okay, because she wanted to talk to my lawyer.
Oh,
to see
let me
the
stop you
charges.
right there. Is
Yes.
that here's what I would like
Yes,
to do. Mr. Uraga, if you feel you need to talk with him, happy to put you in a breakout room right now. I just don't want to have that kind of open conversation here.
Yeah, absolutely, Your Honor. Yeah, I think that's a good idea. And then when the PR bond officer join, he can probably be sent out to the breakout room, and
Yes.
so that way Mr. Flores can give him his information.
Thank you. So
Thank
let's
you.
put Mr. Uraga and Mr. Flores in a breakout room, and when PR gets here, we'll put them there too.
Thank you.
Thank you.
Thank you, ma'am.
Thank you, Mr. Uraga. Okay.
Thank you,
Who's
Judge.
next?
Bottom of page 22, Judge.
Mhm.
Annex, may we have Ontiveros?
Yes, sir. Just one sec.
Why they put me there? I'm watching the other case.
That Ms. Ontiveros?
Yes.
Okay.
In cause number 2020-0D0 1332 and 2020-0D0 2251, State of Texas versus Cypress Eve Ontiveros. Announcement of council, please.
Eliana Elizalde for the state is ready.
Brent Stevens for Miss Ontiveros. We are ready, Your Honor.
Okay, and we are set for a probation status hearing today. Let's see. So there was screening results remain pending on the 22nd. Screen while in custody, client was not diagnosed with any MH diagnosis and was not prescribed any medication. Okay. So the recommendation is to participate in intensive supervision with a substance abuse caseload. Was I there or was I at time? Mr. Stevens, he's like, yes, you were. That's good. Miss Carla or Miss Elizalde? I know what Mr. Stevens is gonna tell me, so kind of, or anyone, want to give me an update?
Your Honor, if I may, that which is on the summary is the update that I actually just related to Mr. Stevens as well. As far as the treatment, this is from the following up from last hearing. You know, as overall, unfortunately, Ms. Ontiveros didn't report much. It was more of a pattern of reporting a couple of months or 1 or 2 months, and then she would not report for several months at a time, and then it was just an ongoing pattern.
Right. Does she have a history of any type of treatment?
No, Your Honor, because let me double check, but I don't believe she ever actually made it to her top initial assessments due to non-compliance and not reporting to her assessments.
And if memory serves, but I'm not going to rely on that. Let me look. Is that there's not a huge amount of criminal history where she might have gotten some treatment, right? I mean, it's basically this case. All right. So the recommendation, Ms. Elizalde, what do you have?
And Judge, I mentioned before that I was at revocation, 180 days. I don't know if I said 180 the last time. And I don't know that, I mean, I'll be interested to hear if help is wanted at this point, right? Just because that's where I'm at right now. Unfortunately.
So, Mr. Stevens, I'm assuming you've talked with your client and she's wanting to participate in some intensive treatment?
I have met with Ms. Ontiveros, and she does want to participate, Judge, and she does have a place to stay waiting for her if released, and she does have a job available. And we also discussed her plans for the future concerning, you know, her friends that she's around, and she's talking about going to school and that sort of thing. But she is in agreement with completing probation. She wants to complete probation. So from talking to her, I believe she will, she was reporting, but based on the records, you know, she would report a while and then skip a couple, and then she stopped reporting after about November. So there were issues with reporting. That was her number one and probably biggest issue. And so she is fully aware that she must report. That's number one requirement for probation is reporting. And she's going to do that.
Let me ask Ms. Carla, the intensive supervision that is being recommended here with the substance abuse caseload, how often is she reporting to her probation officer?
That would be twice, Judge, twice a month.
Twice a month?
Yes.
Oh my goodness. Ms. Ontiveros, you're done in November, is that right? You're done in November. If you're compliant.
I'm 100% compliant. I'm willing to be
I can't quite hear you. I can't quite hear you. And Ms. Ontiveros, I'm fine not hearing you right now. And I don't mean that in a bad way. What I mean is you've messed up on this probation that you have, right? She's on 2 cases or 1 case?
It's 2, Judge.
Yeah. She's on for 2 cases, both drug cases. You've been in jail for a while, but what your attorney has advocated for is to give you an opportunity to utilize probation programs to help you with any difficulties you might have with substance use or anything else. And you haven't done that before. How old are you, Ms. Ontiveros?
I'm 28.
You're 28?
Yes, sir.
All right. I'm gonna go ahead and modify her as recommended by probation. At this time, we're gonna come back in 30 days. I want to see her here. Mr. Stevens, you stay on. You stay on this. We're gonna come back in 30 days and we'll do it via Zoom. If she has difficulty, Mr. Stevens, in being able to come on to Zoom, happy to do it in person. Honestly, wouldn't mind seeing her in person and see how she's doing with the treatment that she will be receiving up until that point. Honestly, unless I get outstanding stellar, she's just kind of on autopilot. You can anticipate having to come back every 30 days until she finishes. Ms. Ontiveros, we're going to get you squared away with this intensive treatment. And it's kind of a short time, but it might feel like a long time. I know your attorney and probation will tell you if you have any difficulties. I don't want you disappearing on me. Obviously, if you're not compliant, a good chance you're going to have a consequence for that from here, just like you did this time. But I am taking you at your commitment to work through the remainder of probation and do so in a compliant way, right? Where you're doing what you're supposed to be doing. And hopefully all these things that your attorney is telling me you want to do, you want to go to school, you want to work, whatever those things are that are positive things in your life, you're going to be able to accomplish. So I want to make sure, Carla, that as we modify her here, if there are any financial conditions, that we relax those. So I don't know if her probation fees were already reduced. If they were not, then they're going to be reduced to $25 a month retroactive. I'm going to waive any fine and court costs. I feel comfortable she hasn't been able to pay up until this point. I really want her to focus on her treatment. Yes, ma'am.
I'm so sorry to interrupt, just really quick. It is my understanding that the officer, Ms. Garciola, is still pending the final, I guess, approval on the screening for the substance abuse caseload at this point. I just sent her a message just to make sure that she hasn't received anything different than what I have. I know she was screened for TAP and she is recommended to attend supportive outpatient for now through TAP.
So the notation on the report for March 22nd that says client was assessed while in custody and met criteria for SOP treatment, that's not intensive?
That is through TAP, Judge, supportive outpatient.
Oh, okay. So we don't know yet if she can go into intensive.
Yes, and I am looking and I don't see any follow-up in her notes as well in the case. So I don't want to, just because I know there's certain criteria, things that get involved when it comes to screening these cases for special programs.
Well, Mr. Stevens, then, I mean, that's the only way I'm going to let her out. So we're going to reset this for Thursday.
Could I say something, Judge?
Sure.
In lieu of resetting and leaving her in jail for another week, could we just order her to report weekly until she's modified?
No. So what we're going to do is we're going to come back Thursday. I am not intending, unless you're asking me to bring your client over, maybe we need to. We'll do it in person.
I'm happy with either way, Judge, but I would really urge the court to let her out until she and let her come back to court in person.
If I don't have a satisfactory answer on Thursday from probation, then we'll address that concern. So, okay, Ms. Ontiveros, we have some information that is missing from probation. So I'm going to bring you to the court on Thursday. Okay, you're still going to be in custody and we're going to have a hearing here so probation can give me some more details on what we're hoping will be a new plan for you on probation. Okay.
Should I call my probation officer?
No, I think, well, I mean, I don't know. I'm not going to advise you of anything. All I know is I'm going to bring you back on Thursday and we're going to do it in person here in the courtroom. Your attorney will be here. And our probation liaison, our probation kind of supervisor is inquiring with your probation officer on certain things, okay? We'll see you on Thursday, Mr. Stevens.
Hey, Judge, Ms. Pineda, could you please email the probation department, whoever, and ask them, let them know that this needs to be expedited if possible?
Yes, sir.
Thank you very
Thank
much.
you. Thank you very much. We'll see you Thursday.
Thank you, Judge.
Okay, who's next?
Middle of page 21, Judge.
Mm-hmm.
Annex, may we have Davila, Eduardo?
Who is Osvaldo Mendez?
I think he's checking in, Judge.
He's a defendant?
Yes, Judge.
Did PR get here?
Yes, Judge.
Okay. Hey, Mr. Gonzalez, we got the big boss.
Good afternoon, Judge. Yes, I was told to check in, so I'm here. I'm not sure on who.
I think they're in the waiting room. It's a Mr. I can't think of his last name right now. And I needed to add a PR component. So he and his attorney were in the waiting room.
Perfect, Judge. I'll be here.
Good to see you, Mr. Gonzalez.
You too, Judge.
Okay, let's go on, Mr. Davila.
Cause number 2022-0D00735 and 2021-0D02285, State of Texas versus Eduardo Davila. Announcement of council, please.
And Leonel Elizalde for the state is ready.
Edward Hernandez, Deputy Public Defender with the Mental Health Unit, on behalf of Mr. Eduardo Davila, ready to proceed, Your Honor.
And Mr. Davila is appearing remotely from the jail annex. Mr. Hernandez, we are set for status conferences in each of these cases, and we are specially set for trial in May. Let me ask right off the bat, Ms. Elizalde, what's the rec?
5 TDC, Judge.
Okay. Mr. Hernandez?
Your Honor, in the last week, we just identified an out-of-state expert that we need to go ahead and assess my client and go through all the medical records and stuff. So we're proceeding. It just, as the court may recall, this is a really unusual neurological medical situation that's so rare. It was just hard to find somebody that could work this kind of case. But we believe we found somebody. We're going to get them all the information, and hopefully we'll be ready for trial by May 19th, Your Honor. Mr. Davila, I will go see you and we'll discuss the case as well. Your Honor, we may, I would like to get another bond hearing. Mr. Davila's brother recently passed away, and he's kind of just isolated there. I noticed that I'm not getting calls from the family like I used to, because his main link to his family was his brother, Your Honor. But I would like to request, again, our position, Your Honor, is that my client, to the extent that he did any act, does it because of the physical injury that he received to his neck and brain area, for which he has been receiving disability for almost 4 decades now, Your Honor. So we're
in terms of the request for any kind of bond relief, please make sure you file your motions and we get you set, because the court's calendar is super full, especially on the inmates, Mr. Hernandez. So if that's part of where we're heading, file it sooner than later and request your hearing. I'm going to leave the settings the same, but I think even if you filed it today, we might be very close to that final judges conference before we get you set. So that's kind of my recommendation for you, is to if you're looking for that type of relief, to file something very quickly so we can try and get you set quickly.
Yes, Your Honor. And I've just informed the court, we may ask for, depending on how long it takes for this expert to do the assessment, he wants to see all the paperwork first and then come into town and assess the client. So I'm not sure how long that will take, but we will try to get it done before trial date, Your Honor.
Sure. And, again, if the court can assist you there with transport, maybe utilizing the court's offices or jury room, just let us know. Okay.
Yes, Your Honor. Thank you, Your Honor.
All right. Very much. We'll go to our next setting until we hear from you. Okay.
Thank you, Your Honor.
Thank you. Your Honor. You are. Thank you,
you,
Mr. Davila. Who's next?
I believe that's it for this afternoon, Judge.
Okay.